I just would like to say this. Adam posted something on LinkedIn a couple of months ago or whatever, and it just gave me a real flavor for how he feels about this work and how happy he is to be doing it. And I've seen him at other meetings and I've met him in person, and I thought, well, maybe he would be good for this. I just had this sense, and then we had this little chat, and then he developed this incredible outline, and but it's so LinkedIn matters, but also for us old folks, getting, of course, Adam doesn't think he's that young, but to us he is, and, getting him more involved. And he's only in this business, what, 7 years, I think you said, or
On
six or
or
seven.
about, yeah.
Yeah. So,
Wow.
so that,
Already
it's,
making a name for yourself.
yeah, see
Good.
that?
Well, thank you for having me. Thank you for having me. I'm a big fan of the pods. I learn a lot in the pods, and I'm happy to participate. And Teresa, thank you for asking me. How should we begin?
I want to say, I'll just say a little bit about what made me think of this topic, and then I'm going to let you really run it after that because you have all this stuff. But we're all going to be talking. And I will say it happens more, like I won't say it happens more in mediation, but my more interesting situations that I will, just let you know about now, which keeps it in my head, and then are what really made me want to do this. When I was first practicing mediation in my basement, I had this couple, and the husband was the owner of an insurance agency that had been in his family for generations. And at the time, the cap on child support was $80,000. And he swore he didn't make more than $80,000. Now, so far, they had done good things. They had sold the big house and bought two smaller houses, and they had two young girls who were like 5 and 6 years old. And we knew he made more than $80,000. And the way the setup was, there was a bathroom in the basement. So he went to the bathroom, and I looked at the wife and I said, "Are you okay?" And she said, "If I fight him, I'll get cancer and die." And I was like, okay, I think she knows what she's doing. So when Adam and I were talking about this yesterday, he said, agency. How do we know? Do we know if they really know what they're doing? Recently I had a client who said there were millions of dollars, not a lot of disclosure. She was getting about six or seven. And I said, again, he went to the bathroom now in my fancy art office. And I said, "Are you okay?" And she said, "If he's cheating me, karma will get him." So are we okay with that? And that's really that's the genesis of this. And I think we'll see it often in our work and even certainly in our collaborative. So um, take it away, Adam.
Teresa, thank you. So, look, I, yesterday with some assistance, put together an outline, which was then much bigger than I think in some ways than we would have time to talk about today. But this is a conversation, and I have many, many more, at least in my practice, many more mediations than I do kind of collaborative cases, even if you want to call it collaborative with little c, or just most of what I do is acting as a neutral. And for me, what comes up a fair amount as kind of both the mediator and the attorney in the room is parties will discuss things that or parties will discuss options or resolutions that deviate very significantly from what I'm pretty confident, I don't know, of course, always, but I'm pretty confident a court would never award. And so as Teresa and I were talking about this yesterday and previously, uh, how do you handle that? How do you handle it? How do you handle it professionally? How do you handle it ethically? I have to be honest with you. For me, it brings up some emotional stuff. And also it depends on who is making the proposal, how it's receiving the proposal. So we thought we would just open the conversation up today, this morning. And I have a question. I know that I can't be the only one this has happened to. I'm just curious, just to kind of, get the conversation going. Um, has this happened? You know, when someone says something that's far outside what a court might do, or suggested something far outside something that a court might award, how do we handle that? And so I'll just put out that question to everyone. Has that happened? Am I the only one? It could be. Okay. I've come to the right pod. Okay. I've shown up at the right Zoom. Okay. And I'm curious, what does that raise for people? Like, what are your first thoughts when this happens? What are your initial reactions when someone brings up a proposal that a judge would never entertain, quite frankly, if it ever went to court? I don't know, Mark?
Mark.
Um, so, and I pretty much learned this from the the understanding model of understanding the Center for Understanding and Conflict. It used to be Center for Understanding the Law, where in the first meeting I talk about the law and I say that we're going to talk about the law at various times because it's too pervasive to pretend it doesn't exist. And when I do talk about the law, I want you to know that I'm not taking sides, that it may feel like I am, but I'm just conveying my understanding, and that you shouldn't take me as the final word. You should consult with your lawyers about it. And it's too pervasive, so we don't want it to become the elephant in the room, but we also don't want it to dominate. So, I mean, there's a nice little metaphor where the elephant is actually this high and he's waiting in the waiting room. And when you talk about the law, you walk the elephant in and he's on a leash and you kind of look at the elephant and then the elephant comes back out into the waiting room and now you've discussed the elephant. The other one is there's a personal table and a law table. So most of what's going on is at the personal table. When you want to discuss the law, you go to the law table and then you go back to the personal table. And you make it very clear that the law isn't necessarily the right answer. Okay. And that it'll either ground you in determining what you think is fair or it won't. And you can accord it as much or as little significance as you wish. Now, in your case, in the case that you raise, where it's really outside the spectrum of possible outcomes, I think I would say that. I would just very plainly say, a court would never do this. I might explain the rationale behind that. And that, again, I would say to them, I mean, obviously this gives a certain amount of power to the person who's in the spectrum but you could even bring in the whole concept of a BATNA. If you persist in that position, which would never be something you get in court, you risk sort of driving the other person out of the mediation and into court because maybe her best alternative will be court, as hard as that is to accept generally. That's essentially.
Mark, I hear a lot there, but I like the idea of a baseline, which I think a lot of us might do, but the law as a baseline, I like the idea of a personal table. It's like Thanksgiving. It's like the kids' table and the adults. It's like, yeah, so like the personal table and the law table, and you could maybe sit at each. And transparency, right? This is
Do we have smaller chairs at the law table?
in my office you do, but yeah,
more comfortable chairs at the mediation table.
Where everybody wants to stay.
Yeah, just transparency in the moment, and I think something that clients, authenticity really respond to, and I think engage with. I know there were other hands.
Well, Rachel and Bob have the yellow hands.
Oh, they're
I
yellow
can't
hands.
figure out the yellow.
I've never figured out how to put a yellow hand up.
Oh yeah, you just go down to
I just tried, it didn't work.
Rachel.
Yeah, I just want to observe that I think this is more of a problem in mediation than it is in the collaborative practice, because going back to the basics of the understanding model, when you are when you're working not as a neutral, you can really sit down and talk to somebody and get to the point where you completely understand why they're agreeing to this. And assuming that they're rational and they understand their rights and their options, I feel, I can sleep much better than in mediation, where I generally am not caucusing and I don't have a chance to just, poke the reactions of the client.
So, Rachel, you're saying more of an issue in mediation than in collaborative because just because of the setup of the different venues.
Right.
Suddenly, okay. Uh, yeah, okay.
Bob?
So, the value of having a full team is that you have a family specialist.
Mhm.
And as a family specialist who's, in my case, trained as a psychologist, one of the things that I try to do is explore the emotions that are causing the person to think. In your case, Teresa, what makes them think they're going to get cancer if they go, or what makes them think that karma is going to get them, or what's behind the reasons that someone is going along with it? Is it that they're feeling guilt because they initiated the divorce? Is it because they're fearful that they're intimidated if they go against? I mean, so the family specialist role, whether it's in collaborative or it's happened in expanded mediations, when it's gone beyond the mediator to call in someone who's trained to, although it sounds like from what I've heard so far, the attorneys can do a pretty good job if they're thoughtful and sensitive to exploring what are the emotions that are causing the person to either make this offer or go along with the offer.
And do they have a new paramour who is very wealthy? Did they just find out that their uncle left them
Paramore.
$3 million?
I can just say in the first case, and I said, they had already done some things right. They vacationed with these girls for like the next 10 years together. Everything worked out. Everyone was happy. It went very well. The second case is too new to know. Nancy.
So I actually have a collaborative case
Okay.
where, and I'm a neutral. So sometimes, as a neutral, you really just explain the facts, so to speak. But, I also have a financial planning hat, like something's not going to work in the budget, but that's what they want in their budget. For instance, even if this person actually lost their job, in their budget is $25,000 a year vacation. Okay. And to me, as a financial planner, if you lose your job, you've got to cut expenses. Where's the first place you look? And that's how I would work with clients. But in this particular case, we're coming down to support, and they have 4 children with round-the-clock care against their personal financial planners, research and stuff like that. They were told not to buy this $2 million house, which they bought, and they knew their job was tenuous. And now they want the moneyed spouse to basically support their lifestyle with all these, like, the add-ons are $15,000 a month. So the moneyed spouse is going to be paying probably at least 90% of that. And then the child support, because at this point, initially there was no maintenance. They want to keep raising, not even having a cap, but going beyond the $500,000 cap and things like that. And I, as a neutral, are like, one attorney keeps pushing for a client, which I understand, but that's not the collaborative way. And it's just, there's such imbalance that it gives me such angst.
So it's not the collaborative way to push for the client, you're saying?
It's
This
kind
may
of
be
like,
another
what is
topic, but
reasonable? And, if your parents end up paying for half the house or helping you out, then you knew that you had that backstop maybe. And why are you asking your spouse to support you really in 2 homes now with 100% of everything, when that financially wasn't the right decision. And it was a recent decision. So the question also in my mind is, if they end up having to pay that kind of support, is there anything that can be put in to say, listen, if you don't get a job that can really support you, maybe you have to sell the house, and take that $1 million of equity that's in there and use it to get income or something. I don't know.
Nancy, and I know Myra, I see your hand up. Nancy, were you able to articulate some element of that during the collaborative process? Were you able to say what you just said?
Well, we're having a meeting about it, and I want to make sure I'm still neutral. And that's my issue.
Mhm.
How do I express this as a neutral person?
Well, it
So then you
sounds like it's just the facts.
Right, it does, and it does
doesn't sound like
benefit
you're taking a side.
everybody if you're not really, in a way you feel like you're advising, I think, a little bit, but
Yes.
right.
And maybe it wasn't something that they thought about. I mean, the person that bought the house wants to live in it till they're, dead and buried. And, you have 4 kids. It's like a 5-bedroom house with room for an au pairs and a pool. I mean, do you need that, or can you sell it at some point to create income? And they're very stuck on, no, she wants to live in the house forever. Thank you for my support group.
Myra.
Excuse me. I find a lot of times in those very unbalanced cases, the person who's willing to take so much less is often making a calculation that the other party is so crazy or toxic that it's not worth them going forward. And that they want to get out as cleanly, for lack of a better word, as possible and go on with their lives. And my own feeling about that depends on what circumstances they're in. If they're self-supporting, if they have a future, so they don't get half the country home, you could see financially they'll be okay, maybe more than okay, and maybe not going through this for another year or so or whatever it is, or destroying the children in the mix of what the children will be put through. Then I can see as an intelligent decision. I don't need the, whatever.
The
Where
price
they're
of
not going to
freedom.
be, yeah,
The price of freedom, right?
But
right. And they're willing to pay it, and they're making an intelligent decision because it's not worth another year of their life. And in fact, for many parties, the divorce process is actually destroying their work life. They're creative people, they're authors, they're journalists, they're artists, whoever it is, they talk about it. Often they view the term the dead time in their career or something like that.
Wow.
If they're not able to, that's when it's, they're giving up something really important to their future. Then that's a real hard thing. No matter what role you're in, to kind of watch them do, because it's like, the person who, and in one case, person literally did it, the person who holds their breath and goes on the floor and gets everybody around them to help them recover, the crazy person wins. And that's hard.
The crazy person.
The
But,
crazy person is the most powerful person
Yeah.
in the room. Yeah.
Literally, I had a case where even in court, when it was in court, the guy would literally hold his breath till he turned blue, and everybody was scattered around him.
Oh
Was
yeah.
he wearing a blue
Yeah.
shirt to match? I mean, was it?
Mark and I just had that case.
So I understand the concept of, what, I just want to get done at any cost. But that's a present thought.
Emotion.
It
Emotion.
is.
What about the future, 5 years, 10 years, when you're carrying
That's a
that load
problem.
on your shoulder?
Right. And 5 years from now, and the other person got the house, or the other person, that's when they regret. But
I think that so many of these examples that we're talking about, they're so imbalanced, which is not necessarily it's not really what I see most of the
Right,
time.
right.
There's something that might be different than what a court may award, but there's consideration for that in some other area. And
Well,
in
we might,
terms of
I'm sorry.
counseling my clients about that, or the mediation couple, I just walk them through, these are sort of the realm of possibilities, but we want to see what works for you. And okay, so if, one spouse is going to have exclusive use and occupancy over a house for a longer duration than they may otherwise have received from the court, what is the consideration for that? Because now the other person can't go and buy something, right? So,
Right, right.
and I think that those are the nice, happy things that happen for mediation and collaborative clients because they can fashion an agreement that speaks to them and what their specific needs are.
Mark.
To that, to Tracy's point, I think that we need to, we all know this, but we need to screen for the appropriateness to the process, right?
Mhm.
And it's not just when we first meet them, it's throughout the mediation. You might find after 3 meetings that this is not working. In terms, not when I say not working, I mean the dynamics are such that the person in the one down position is clearly in the wrong process.
Right.
And so we need to really, I think, and I include myself in this, I think sometimes we tend to, I think, of a bias toward, oh, this will work. We'll get through this, or, because we see so many cases that seem so knotted up and difficult, and then somehow parties make it through that and get to the other side. I always normalize that feeling that they have that they're not making progress, or that, by saying, when first of all, I tell them this is a dispute resolution process. Of course, there's some conflict, blah, blah, blah. But and for collaborative, that's a whole other thing, because I don't think there's much screening that goes on, because I think there's this bias toward, hey, if they want to stay out of court and they want to work this way, who are we to tell them they can't?
And if we can get a collaborative case.
If we get a collaborative case, it falls out of the sky. This is for everybody, and it's not, because if they can't sit in the same room in mediation, why can they sit in the same room with 2 lawyers or and a whole team there? And then they go out. If we take them in and they weren't appropriate, they go out and say this collaborative process is full of
Right, right.
right. But now I'm getting off on, because there's a whole other issue. Well,
Rachel.
Yeah,
I just want
We'll come back to you, Mark.
I just want to observe that also.
I'll put my hands under the table.
Results in litigation are not always perfect. Just want to throw that into the mix.
They're not?
No, I mean, we have I feel like we have very high standards, and, in thinking what's ideal. And I mean, it doesn't seem like the ideal happens in litigation necessarily, because people they have much less control.
Yeah, but I don't think you have to think of it as an ideal. I mean, it's ridiculous to think of it as an ideal, right? To say that, well, since that is a bad, the other option could be 2 lawyers negotiating who are maybe litigators but know how to settle cases,
right,
and can be reasonable, and it's not in collaborative, and they're not, and they're essentially lawyer to lawyer. But sometimes we shift to that in collaborative, don't we? Because we're pragmatic. If they stop being the meetings stop being
productive,
then just apply
helpful,
the law.
we shift to, okay, we'll do it we'll do it another way. We have to be pragmatic and not ideological when it comes to that.
Mm.
I'll try to shut up.
I have to say, just as, again, as someone both facilitating very lightly, but also listening, I think there's just a lot of meat on the bone here, as an understatement. But, a big part of it is evaluating, the client, the position, the agreement, the proposal, whatever it is, in the moment, right? feel all of this, it's all an evolution, right? The client who comes to you might not be the same, maybe a very different person, or maybe thinking very differently, both throughout the process and towards the end of the process later, 10 years later. And there's, and something that's always drawn me to collaborative is the value of having a team.
Mhm.
And it always strikes me that, the team could be made up of many different people. It could be made up of someone's personal psychologist. I mean, yes, they may not be in the collaborative room as such, but helping, really counsel a client to separate their emotional self from the logical self as they go through this process is really critical. And it's just very hard for any one of us, regardless of what role we may inhabit at the moment, to be all of the things at once. And sometimes,
Mhm.
especially if I'm it doesn't matter if I'm the lawyer, if I'm the mediator. I feel like I'm wearing a lot of hats. And I'll say to someone, I think you should really talk to your psychologist about, or your psychiatrist about this, as we go forward. Anybody else? Have another, I have other questions or
Yeah,
other pivots.
yeah.
Okay.
Take the pivot.
Okay. So it's interesting. And Tracy, I really hear what you're saying about, the degree, right? Like, is it a wild deviation, or is it just like a little bit of a deviation? And Rachel, I take your point, like, what happens in court, we don't know anyway necessarily, and results may not be exactly what we imagine, regardless of how much, law is out there to begin with. So towards that notion of maybe a smaller deviation, if when someone proposes to you, let's say, a smaller or when, what, let me frame this a little bit differently. When your client wants to propose a more modest deviation, I'm curious as to how people do that. It's a deviation. The client, I don't know, they want something that is maybe unlikely to happen in court. I don't know how to say it. This has been already
Mhm.
been a lot of discussion on this. But you sense this is not something that would unfold in court in the way that it's being proposed. It's not something so off the planet that you don't feel uncomfortable. You feel like you can present it, but it's going to have to be presented carefully. And I'm just curious how, people work with the client around that, and how they present it to the other side, or to the team, or to the mediator, for example.
And I want to say, I think for in the collaborative context, is it something that's coming out spontaneously in the room, or is it something that your client has said to you beforehand, that they want? And I think that may be more the client tells you this is what they want, and now you're going into the collaborative room, and what happens with that? Has anybody had that kind of experience? I guess not.
Or not.
Oh, I haven't had that kind of experience necessarily in a collaborative context, but I think just in general, I think you would want to
Hmm.
present it as this is my client feels comfortable with this. These are the reasons why. Here's the benefits to you. Here's the benefits to your family. And sort of put it out there for a discussion.
Hmm.
Presenting it, Tracy, as like a win-win.
Yeah.
And also, I hear something else in there. Why? And these are, I don't know how much, it's attached to values, right? Like, this is kind of what we believe. This is aligned with values. I thought I saw another hand go up. Myra?
Myra.
So sometimes what may not make what should I say, anywhere close to the law may nevertheless make economic sense. So I did have a case where the parties earn very close to the same thing. and they were sharing the children equally. But the real catch was that the husband earned slightly more, so might have been the child support payor, but the wife stayed behind in the rent-controlled apartment. So when you looked at their monthly economics, she was actually in, even though he earned a little more, she actually was in a much better place paying a fraction. And so it just looking at their incomes wasn't the whole picture of their lives, looking at what their expenses were. So it wasn't just, I'm not paying child support to you, but you got this, apartment and you have a very low budget. And so, in other words, it was, in the sense, though, not the law, it was actually economically sensible for both their households to end up in, a relatively equal place, even though a court would not do that. And so sometimes you can find a rational justification for something that's not insulting, doesn't sound like it's greedy or whatever it would be, but it takes care of both households in a way that actually makes sense and something the law doesn't take into account.
I mean, I use that as the easiest example of why the guidelines don't always make sense,
Right.
and why we want to see what your budgets are. If one of them is living in a home that they pay no rent for and that's permanent and they don't have to ever worry about it, they don't need the same kind of support, that level of support. So
I asked towards, Myra and Tracy, just kind of following up on that for a moment. Is it mostly when, we presented this as kind of, what happens when something kind of comes outside of the bounds, whether it's your client who's advancing it or whether it's coming at you from the other side? Is it mostly financial, or is it also in connection to parenting plans? I feel like sometimes I do a fair amount of like mediation in connection to custody and visitate parenting plans going forward. And it sometimes it's a place where we get stuck. They're okay with the money.
See, but that's
they're fine on the financial stuff. We get stuck on like Halloween or something.
Yeah, but what I say is, when you got a team, it then doesn't become parent A versus parent B. You can also look at the developmental needs of the children. You can talk to who's the parenting expert. It's not personal. It's not who's the better parent, the favorite parent, the whatever. Your child under these circumstances at this age needs that. And then I find the easier one to kind of finesse, where you sort of depersonalize it and can draw them in from the child's point of view, if you can. Sometimes that's easier, it may not feel good in the moment, but also, you're looking at the long life of the child, where sometimes money is more immediate. And, and it's numbers, and people have a lot of fear about that. But, if you don't get Wednesdays this year, maybe you get it next year. There's a lot more, I think, way to move in our colleagues that we work with who are experienced in child-related matters, I think really know how to talk to parties about seeing the child's needs, the point of view, their particular difficulties or challenges. So
Yeah, I think with parenting issues, there's just so much more discretion, so many more options. So when
Yeah.
you're saying, is this out of the realm
yeah.
of, what might happen in a different setting? Who knows? It varies judge to judge. And,
Right.
so I think that that's a lot more about each parent's comfort level. And I think probably the hardest thing that I deal with, and probably the rest of you who deal in this field, is when people say they want 50-50 parenting time. Well, what does that mean? Does the child need to sleep somewhere else? Like, what does that look like? And I think that's just that's probably just at people's core the hardest thing to get over for a lot of clients.
Tracy, is that also a place where you would bring in a child specialist or, I like, yeah, go ahead. I'm sorry.
No, yeah, I think that if the parties are open to that and listening to that feedback, that's great. I think so many are not. They think I love my child. Of course, I want them half the time. And like I have one case right now. It's not collaborative. It's a regular litigation. And you know, dad's proposal is like literally every other day. Like he wanted the kid to sleep at his house Monday night and then be with mom Tuesday night and then Wednesday night. It just frankly made no sense to me as a parent. Um, it was just very much like this child is mine. It's half mine.
Mhm.
And also, yeah, I was going to say there's sometimes shame or fears of shame, like, wait, I thought you were a good parent. How come you only have your kid, X amount? I mean, there's so much mixed in. It's not just time, it's not just what day. There's so much primal fear also. Am I going to lose my connection with my child? Am I going to, there's so much. And that's why I think our team is really important on those issues. And of
And it
course,
would
if your
seem,
kid is now today at, 5.5, isn't who they're going to be at 7.5. And, getting them to understand what that big picture looks like. It's not really a legal issue from my point of view.
right. I was going to say, I mean, how do you, what could you say? Well, if you went to court, this is what you're going to get. And that's not going to help anybody. That's not going to help anybody. Did you want to say something, Mark?
Oh, well, I didn't have my hand raised, but now that you ask, I just wanted to quickly. I heard a great quote at it was actually Julie Stein was leading a group about a podcast like this, the Manhattan Pod people, uh, about
Yeah.
neuro,
Hmm.
and the quote was, "The closer you are to the judge, the further away you are from your children."
Oh.
I think that's a very powerful thing to say. More powerful, I think, than saying, if you go to court, it's going to cost you $100,000 as an admission ticket, and then your kid's going to have to do this, and it's going to be horrible for your kid, and he's going to, they know all that somewhere up there.
Mm.
But I think that might really like go, holy shit, I'm
Mhm.
abandoning my
Good
kids, but
visualization.
uh,
Bob,
Bob, not that I'm the person to call on people, but
As long as you brought this up, Mark, I just want to put in a plug for on the second Tuesday of the month is when the New York City pod meets.
yes.
At this coming meeting, Barbara and Judy Stein are going to be talking about developmental needs of your kids to help
This
exactly
is a
what
great pod.
what we're talking about at this point. I mean, both pods are
I
fabulous.
want to do that.
Yeah, yeah. This is my first, by the way, LI pod, and I'm happy to
Woohoo.
be here. The first of many, I hope. But
Me too.
but I'm like my schedule always has the New York City pod in it.
Yeah. Yeah.
Yeah, because it's just a good group of people.
And you're
Good
New
time.
York City centric.
Manhattan, let's face it. Come on.
I would like to talk a little bit about maybe this brings this topic more into a different focus. When you're in a collaborative case and your collaborative counterpart doesn't want to deviate from the law at all.
Hmm.
Mm.
I've
Have we
heard of
had
that problem. Yeah.
have we had those kinds of situations?
Mm.
And what do we do there? For instance, I mean, I had one, not an NYACP collaboratively trained member, would not have the initial meeting without full financial disclosure. Net worth statement, 3 years of everything, would not sit down without it.
Hmm.
What do you do?
Is this a type of case where there's been a collaborative participation agreement signed, like it's formally
Of course
collaborative?
not.
Oh, okay.
Of course not.
So it's not the big C.
Correct, correct. Which I don't even like saying little c. It's not collaborative, so maybe I shouldn't have brought it up. But so, have you ever had it in a real case? That's a good question. In a case with a participation agreement where someone has a whole different idea of what the roadmap is.
And
And
unilaterally dictates the process.
right.
Right.
Then that's
Well, I guess unilaterally dictates is redundancy, but
I'm supposed to be facilitating, but can I say
I'll
something?
call on you. That is okay.
Okay, can I actually
we don't want to hear what you have to say.
this
You're the
comes up
moderator.
for me in a non big C collaborative setting. This comes up all of the time, which is the level of transparency that we have. And I'll when clients first come in, and I'll say, could maybe so I can really get an understanding of what's going on, could I get net worth statements? It's like I just asked them to I don't know, put everything on hold for the next 6 months and work on this 23-page document. And I have to say at time, and so they I end up following them very often. If they just want to give me an Excel spreadsheet, if they want to give me statements, like all of you, I have like a client case management system. They upload stuff to a portal, and it sits there, for everyone to look at. But I have to say, at various times, I find it very anxiety provoking when issues of transparency come up. And although I don't like the hard, I will only do this if X, Y, or Z, I don't like those bright line moments. I find, myself getting, like reverting right back into, okay, well, if you're going to say 1, 2, I'll say 3. Like, we'll go to litigation. Like, that's my best. I don't like that. I don't like ultimatums, and I don't find them very helpful. But I do say I worry when there's not been maybe as robust as I, as an attorney, might like a disclosure, let's say. But the clients are like, we know what we got, and that's pretty much what Adam has. That's what Teresa has. Gesund, let's go. I don't know. So that personally challenging.
Also, we never assume, in no matter what kind of case we're doing, that you get a net worth statement and that's the whole story. And sometimes intentionally, but also there are people who don't understand, the terms, and it's one of those forms where it's not user friendly. You get a big amount of space for something, a one-word answer, and no space for something that's paragraphs to them.
Like Myra, source of funds. They always say my money, my cash, my account.
So, I don't know. And I agree with you. I've had people over the years who, they couldn't commit to it, because they're signing onto it. And so every month it would change. And so, like, every month they want to update it. It's just a tool. As I think, Teresa, you started this off, I guess it wouldn't bother me that somebody wanted to start with some kind of outline of the party's finances. But that's usually also when we have our financial people, they have their own stuff anyway. So you're almost wasting their time having one set of formal things when our financial people have their own way of doing things and can work with the parties how they want it done. So I think it's just, and then what do you do with it? I guess is the second question. Okay, you want everybody to fill this out, and then what? We're going to spend, 50 hours going over it, or how do we get to the real discussion here?
It's really interesting. And one of the things I say about mediation and about collaborative is, from day one, we're trying to help you resolve issues. And if you're spending 6 months doing a net worth statement, that ain't happening. And it's just not happening. Okay.
Nancy.
I would
Nancy,
hope that,
yeah.
Oh, I'm sorry. Yeah.
So as a financial person, my first meeting that I have, which takes about an hour, I go through how they have to complete that affidavit of net worth form. So
You mean
besides
how
all
to?
the, what?
How
How
to?
to?
How to, yes.
Right.
So I have them both on the call and I go through the whole form of what's needed, what documentations are needed and
Great.
things like that, and then how to complete the post-divorce budget. So I have all that information that I'm, how to gather it and things like that to move the process along. And then later I meet with each of them individually after they've given me the information to make sure I have everything. But that's the part where it's the gathering of information and someone else is basically, like putting it into a format for the attorneys to see and the group to see. But maybe that would help to say, listen, why don't you go to a neutral to
Right.
gather all this information to help you through? Because it is so overwhelming. I mean, when I give them the form, I say, you can look at what information you need to gather, but don't fill it out because you're going to fill it out incorrectly. You're going to be so overwhelmed with the details and you're going to get frustrated.
Right.
So that's what I
Right.
do.
That's
Tracy?
great.
Tracy?
Oh, I was going to say a comment that Teresa, you said 6 months. That I hope is very rare that it takes someone 6 months to complete the net worth statement. I mean, we've all had those clients or parties who just really can't get there. I have one right now in a non-collaborative case. But I in my practice do a little bit of what Nancy does with the clients. I sit down, I explain to them, this is what we need. Here's how you're going to estimate your monthly expenses. Make sure you send me a statement that confirms the balance as of this hopefully date of commencement or whatever date you're using, so that everyone has that transparency. So everyone has insight into what the parties have amassed, right? What is marital property? What is your separate property? I think everyone needs that disclosure. And so, if you have an attorney who's saying, absolutely not, I will not sit down, I guess my question is, were finances the only issue in that case? And they just didn't feel like it was productive to meet until they understood what was happening, or they're just so rigid that, yeah.
So in that case, just to answer your question, they were in mediation and they had an NYACP financial person do all of the finances. And this lawyer wanted to see the backup and the bank statements and yeah. And I think it was a little bit, I think what she felt was there was a power imbalance. I had the husband who had the big retirement income. We all should have been firemen. And he controlled the money. So I think she was, a knight in shining armor for this woman. I think she took on that role.
Teresa, don't see from my point of view, the financial people look at the backup stuff.
Correct.
If we're working with somebody, I don't know if
Correct.
they've verified all this, they
Correct.
verify the numbers,
Mhm.
that's good enough for me.
Mhm.
Is it
Right?
more so a mindset of the attorney? Do you think that, if we were in court, the process would require a statement of net worth. And in the agreement, the parties are going to represent that they have done this exchange. Otherwise, we're going to have to specifically say that they've waived the exchange. And it's a signed, notarized representation from the parties themselves. Is it that mindset, or is there like something that the attorney thinks is hidden due to the power imbalance that you were talking about?
Right. I guess that's what she
If
felt.
it's just by way of process, I mean, I don't think I'm with Myra. Like, I don't think I would have a problem with just like getting it accomplished to move forward. I've been on cases with attorneys with just a mindset, like, but this is how it goes. Like, we have to file a summons. That's how you start a divorce. Like a similar. I mean, that's what the world I came from too, so I can appreciate it. But some attorneys are like this. Like in New Jersey, there's something called the case information sheet, which is actually worse, in my opinion, than the statement of net worth. It's so daunting and annoying. But like we have a truncated form that we've have formulated ourselves that provides all the information of a statement of net worth or case information sheet. And sometimes I'll present that to the other attorney and say, we have this, form that is a heck of a lot easier to fill out. What do you think of looking at it and seeing if that would be that would suffice for you so that we can fill those things out. At the same time, that's not a signed notarized document. So I would be interested to know what the motivation is. Is it just by way of process, or is there something
Like this
deeper?
signed and notarized document, how many people like wind up at trial like, look, your first net worth statement, you
It's
lied.
wrong. Right, right.
This pays off,
Yeah, and you
this
can
accounts
update
out.
it,
It's like, it's a
and
little silly.
yeah, and you update it ahead of time, and the first
Right.
statement of net worth is not really the one used. But I'm just wondering, the point is obviously they're not in court, right? Teresa, you're not in court right now on that
Correct.
case. So the
I'm
point
actually
is
out of the case.
to reach an agreement outside of court. So perhaps the mindset is we need a represented document to cover my butt as, the attorney exchanged. I don't know, like if that's the motivation, but I've seen that.
Hmm. But we don't really want to see it in collaborative. Am I right about that?
It just seemed
Well,
this isn't a collaborative case though.
Well,
and Teresa, in your case, you said it was like a little C, right? So like, did you have a
yes.
financial neutral? I'm sorry, I don't remember if you
No,
said.
they had a financial neutral when they were in mediation.
Oh,
The
okay. All right.
mediation broke down, so they wanted to do collaborative. But the wife did not hire someone who was willing to sign a participation agreement.
Mm,
First she was, then she wasn't.
mm.
But just going back to, I think, the original topic a little bit, do you have cases on occasion where the other collaborative attorney is kind of just stuck on the law and wants to do it according to the law and seems more like what we used to call litigation with a smile? Does that happen? Has that happened? And how do you deal with that, Rachel? Can you not unmute
A
yourself?
direct question.
Yes,
Teresa,
sorry,
did
I
you
was
ask-
I was
Oh.
on another screen. I have not had good experiences in that kind of situation, and I've gotten to a point where I won't take a case unless they will sign the participation agreement, because I just think it shifts the whole discussion in a different
Mm.
direction.
But have you ever had it when there is a signed participation agreement and that still is sort of the mindset of your collaborative counterpart?
Well, I have, but then I find that if I'm having a conversation with that person and I just remind them, like, why are we, this is what the clients are saying, and we're here to support them. Remember what we're doing, and that usually gets us back on track.
That's great. That's great. Anyone else? That kind of scenario. All right.
So Teresa, Nancy, I don't, I have to say, I'm just watching the time. I I think there are some really remarkable themes that kind of emerged a lot in this or emerged several times in this conversation, but not the least of which is that, a reliance on the team, to support
Yeah.
to support the parties, but also, to really encourage people to use the team, whether it be in connection to most obviously financial issues, but also maybe in connection to child development or parenting issues, is really critical. And the basis, if you will, of the topic of conversation is what happens if there's a proposal or a resistance or something that's way outside what the law would grant. It strikes me that what we were talking about in terms of support, using the team, transparency, client autonomy, was writing a little bit here and there as we spoke, going back to the law as a baseline, and maybe reminding people of it, all the while examining with them, and I think in a thoughtful way, either why they're taking a position or why they're accepting a position that might not be, let's say, what one would get in court, maybe, is really kind of what collaborative is all about. right? Like this is it. But Mark, I know, and Myra, I know you want to say something, but like this is the whole thing, right? It's that, you know, in a different approach, but specifically, I think in a collaborative approach, maybe in a mediation approach, you're really kind of, you know, following the client and trying to support them, even when, you know, the moment feels, you know, for us is whatever, you know, discipline, you know, we're in, kind of feels like something that is a little bit far outside the field. I'm sorry, Mark, Myra, maybe Mark and Myra. I don't know.
Mhm.
Just on bringing in the law, I do think, you know, when you hear the proposal, right? Like we're not jumping in. So, oh, let me tell you about the law. You know, it's we we want to hear the reaction. We want to then ask each of the parties, you know, why that's acceptable. Why? Oh, what do you think of that? What you know? What are your interests that are, you know, met by that position? And really, you know, everything you can learn about what they're thinking and why something is important before you bring in the law, right? And so it's kind of like, by the way, you know, it's not because otherwise it does seem like immediate red light. No, you start again. You're way off. You know, can't talk about it.
Preparation.
Yeah.
Yeah. Myra.
I would just add, when I, meet with prospective clients or when I'm still working with them, I tell them that the process is, in part, we're helping them write their family story and their own family story. And so, particularly if they're children, it's easy to say, is it that, my parents had problems and they split up, but we're still a happy family and we're get along and we do all this stuff, or my parents had problems and split up and it was a nightmare and I can never, and part of that is fitting in, helping this story of what you did and all that. And that's not necessarily what the law is all about. And so we know it, but, we're now writing the next chapter of your family. And, that's kind of, my way in around the law or how to acknowledge the law, but also figure out what's right for this family and for each of them.
Yeah,
I
it's a
think that's
foundation.
great. I love that.
Yeah, I do too. Mark, I just want to respond to your comment in the chat about getting a reputation of being that is
Getting?
cracking up compared to litigation fees. That's all I have to say.
Well, that's a reality, but how do you get that to the powers of, you know, that's what the public, it's what the public, so-called public is thinking, not the truth,
Yeah,
not the
I'll
reality.
I'll
You
add
know.
to that. I'm the attorney for children on a case that, as of last year, cost one of the parties $7 million. So I'll just leave it at that.
There you go.
But I
Okay.
think the other,
I'm sure they hear you guys out there and they realize they're wrong. That's what
I
I'm worried
think,
about.
I think how
How do
we
we
help
get that
clients,
message to them? Sorry, Teresa.
no, I'm sorry. I think how we help clients with that is our real commitment to us, our real understanding that, look at some of your other cases. If we had even in your mediations, if I had a financial and if I had a family specialist from the beginning, this case would not have dragged on for 2 years, and I would have known things that I didn't learn until 2 years later or whatever. So we have, it really is a cost savings. We have to really believe that, know it, and convey it. It's so true. It's
Right.
so true. And it makes it so much better all around. The financial person's going to uncover stuff I'm not.
Right.
The family specialist is going to get to stuff I don't get to as a mediator or as a collaborative lawyer. And
And
Mhm.
then they're going to know how to talk about it better than we would, right?
yeah,
We'll stay in
exactly.
your lane for each of us.
Right,
I mean,
right.
probably there's not stats, but I would be interested in knowing, like Berkman Botker, what do they make on a typical litigation case and what do they make on a typical collaborative or mediation case?
But as John Haynes said, a billable hour is a billable hour.
Um, what was I going to say?
All right, Kristen.
All right, you know,
While
Oh,
Mark
yeah,
is thinking.
what I think is very useful to tell people in the first meeting is uh, go see a family specialist. Just make contact. Let
Mhm.
them tell you, describe to you how they work, what the process is, what they think they can do for you. I know that I was talking with Randy Heller the other day. We had a long Zoom, and one of the things that came up was this, and she said, anytime, a half hour, free Zoom, anybody, to talk about the process with
Yeah,
me.
yeah,
And
that's
and,
great.
and I think that's, yeah. How
Yeah,
can people turn that down? I mean,
right.
it's not going to cost them. They don't have to leave their house. It's on Zoom, and they may realize the value that way.
That's great.
Yeah.
Kristen.
so it's after 9:30.
Wait,
I want
Kristen.
to
Oh,
thank
no.
Adam
Wait, can
and
we,
Teresa.
Kristen talk?
Oh, I'm
Okay.
sorry.
It's okay. Um, you know, I completely hear the concern, and I've struggled with that same concern. And I think what everyone is saying is like conveying it and having people believe it without having done what, like the history that we have and the knowledge that we have of what litigation is.
Yeah,
Unless you're in it and go through it, it's really hard to sit in that seat and say this is a better process.
right.
So Teresa, I think what you're like, really convey it and mean it and believe it will help. I also, going to a specialist like a child specialist or family specialist, like Mark brought up, to help with issues surrounding parenting time. I mean, that's going to be more cost effective to utilize
Right.
that professional
Right.
to help them figure that piece out than my attorney rate and the attorneys going back and forth and trying to figure it out.
Right.
So I think like I struggle with it because I know that that's what people are thinking with the collaborative process. And I think that if I was in their seat, I would think that we need all these professionals, like all that, it's going to be so much more expensive that way. So I think it's our role, it's our job to be passionate, so passionate about it and show that like not only does this work, but it's going to help on cost, not just because of my experience in litigation, what I've seen, but because you're using professionals that are more affordable and more specialized in
Right.
solving
Right.
these issues than
Right.
I am.
Right.
So it doesn't make financial sense to utilize me in that negotiation back and forth when you can use this alternative professional at a lower rate who know what they're doing more so than my negotiation skills.
Right.
But
Right.
it's hard. I mean, I hear what the concern is. I'm sure that I know that the concern exists because it's also in my head and it would be if I was a client. So I'm just reiterating what everyone is saying, but that thought of comparing A, my rate, and B, where I excel versus somebody else maybe would be helpful in getting them to believe it.
Bye, Bob.
Okay, so thank you. I also have another meeting to go to.
Oh,
So I
sorry.
want to thank Adam and Teresa for putting together this program. I know we didn't even get
Thank
to
you.
half of
Yeah.
what you had, Adam. So, and Teresa, so we can always do a part 2. And I
Yeah.
also hope to see everyone at the gala on Thursday night.